on pages 3 and 4 of LX 188. We believe we have an agreement in principle with the plaintiffs and the state defendants. We're still nailing that down just to make sure we're all on the same page. And then, of course, we have to implement that agreement. There are some adjustments that need to be made to various documents. But we're getting close to that, and we're hopeful that by tomorrow morning, we'll all be able to jointly move in the necessary information, Your Honor.
Ms. Riggs, do you wish to speak to that at all, or did he sum it up
pretty well? And the short of it means we don't need to hear from Ms. Strack again today.
Okay, good deal. I don't know that I officially said this, but it looks like everyone's here and we're ready to proceed, so we can officially go back on the record. All right, that's fine. To wait until tomorrow morning to move in that evidence. So long as everyone's in agreement with that. Just so I've got my brain wrapped around it, right now, the legislative defendants have not rested, but we're pausing their case so that this issue with this one exhibit and perhaps others can be worked out while we hear the rebuttal case from the plaintiff. I'm right in that.
Yes, Your Honor.
Okay, just want to make sure that we procedurally are. You know, sometimes it's good for me just to restate it so that I know kind of where we're at. Mr. Patterson, let's see here. You were in the middle of your cross-examination of Professor Quinn when we stopped yesterday, right?
That's right.
Okay. Are you ready to proceed with him?
Yes, I am.
Okay, can we let Professor Quinn back into the courtroom? Good morning, Professor Quinn. Can you hear me okay?
I can, Your Honor. Good morning.
Good morning. Glad everything's working out. I can hear you as well. Okay, then I believe we're ready then, Mr. Patterson, for you to ask your next question of this witness.
Okay, thank you. And for the record, this is Pete Patterson for the legislative defendants. And good morning, Professor Quinn.
Good morning, Mr. Patterson.
Morning. I'd like to bring up PX 124, which is your report, or your affidavit, which we were looking at yesterday afternoon, and go back to paragraph 2. And I'd like to specifically look at the part where you're quoting Dr. Thornton's testimony, and you say that she dropped an ellipsis about 500,000 licenses. And if we go to the end of that sentence, there's a call down to a footnote 2. So if we could go there, and so that says rough transcript of April 26th at 1:46:18 to 21. So I'd like to bring that part of the transcript up, and we've marked the April 26th transcript as LX 269. And I'll start here at line 14, which is the question that prompted the answer that you cite in your affidavit. And the question, Dr. Thornton, isn't it true that though Professor Quinn clearly states in his report that he included canceled, suspended, and inactive licenses in his matching analysis? And then the answer, I stated that, as I believe I stated at my deposition, he did remove a number of those with these status codes. After my deposition, I went back and double checked, and he removed 500,000. Now that dropped about 500,000 language is not there in that answer. Is that right?
I guess removed 500,000 would have been more accurate.
Okay, I think there may be another passage you intended to cite, and we're going to look at that in a moment. But before, let's stay up with this one for a moment. As I think we established yesterday, you did remove about 500,000 licenses, or with the status code canceled, suspended, and inactive, correct?
So as I believe I testified yesterday, if one interprets license to mean license number, I don't think that's accurate. If one interprets license to mean license issuance, which corresponds to a status code, then yes.
Okay, and you stated in your affidavit that you removed about 500,000 licenses with those status codes, correct?
My declaration of April 27th, I believe that's correct.
Yes, okay. So now if we move down to the next page, we're going to go to 147, line 23, and this is where I think you got that quote from. Okay, and this is not in your disclosed expert report anywhere, is that correct? And the answer, no, it wouldn't be, because you asked me the question at my deposition. And I responded at the deposition that there was specific code in Dr. Quinn's programming logic related to dropping certain of records with these codes. I wanted to know how many were indeed dropped after you asked me about it, and it's about 500,000. And so does it look like this is the language that you intended to quote?
I believe so, yes.
Okay, and this is consistent with Dr. Thornton's earlier testimony that is also consistent with what is in your affidavit, correct?
When you're stating Dr. Thornton's earlier testimony, are you referencing the paragraph we just saw a second ago?
Yes.
Yes, I believe that's correct.
Okay, let's go back to your affidavit now, which is PX 124 again, and I wanted to go to paragraph 9. And so this is talking about the individuals with multiple non-active status codes. And so I'll just read it, and then I'm going to have a question or two. So for the 4,360 individuals identified in Table 2 who have multiple DMV license status codes, but no active DMV record, I remove expired IDs that expired prior to September 20th, 2019, except for those individuals who were 65 years of age and older, whose DMV issued IDs was expired on the date of their 65th birthday. And then the next sentence indicates that you removed 2,691 individuals based on that expiration parameter. And then in the following sentence, you say there's one individual who only had a permit, so you remove them. And then you say, this leaves 1,668 individuals with multiple DMV status codes, but no active DMV ID that is unexpired and acceptable for voting under SB 824. These individuals were removed during deduping as the likelihood of an individual with multiple non-active status codes possessing a DMV issued ID appears to be incredibly small. So just to make sure I understand, these 1,668 individuals with multiple non-acting DMV status codes, you removed entirely from your matching analysis, is that right?
These 1,668 individuals were not in the DMV file I used for my matching analysis.
And what is your basis for saying that the likelihood of an individual with multiple non-active status codes possessing a DMV issued ID appears to be incredibly small?
So as I testified yesterday, my understanding is that these non-active status codes are not valid IDs and thus are not qualifying under SB 824. Since they have no active ID, it seems unlikely that they would have a valid ID.
Right, and is this because it's your understanding that under North Carolina law, if you have an ID with one of these statuses, they're supposed to be returned?
In some cases, I believe that's correct. I don't believe that's the case in all cases.
Okay, and so what, do you have any quantitative or empirical basis for saying the likelihood of an individual with multiple non-active status codes possessing a DMV issued ID appears to be incredibly small?
What I can tell you is that these individuals don't have an active ID. And the other thing I can tell you is that there are 1,668 such individuals out of about 14 million DMV records. So that's a very, very small number of people. And it's also the case that there's no guarantee that these individuals are even in the voter file.
Understood. And my question, though, was what was your empirical or quantitative basis for saying that the likelihood of these individuals possessing a DMV issued ID appears to be incredibly small?
What I was referencing there is that they have no active status code, and thus I don't think they have valid ID.
Okay, and you left individuals with a single non-active status code in your analysis. Do you have any basis for saying that these individuals with multiple non-active status codes would be less likely to possess a valid ID than individuals with a single non-active status code?
So I think it would be not inappropriate to include these individuals in that group of about 1.5 million individuals that I already included. But as I stated, I don't think that this particular decision that I've made here will have any appreciable impact on the results that I reported in my main report.
Understood your position on that. I'm just saying you don't have any basis for thinking that these individuals with multiple non-active status codes would be less likely to possess an ID than individuals with a single non-active status code, do you?
Objection, Your Honor. This question has been asked and answered.
Just 1 second. Overruled. You may answer the question.
I'm sorry, Mr. Patterson, could you repeat the question, please?
Yeah, I'll try to get it what I had asked. I believe it was you don't have any basis for believing that these individuals with multiple non-active status codes would be less likely to possess a qualifying ID than individuals with a single non-active status code, do you?
Compared to the individuals who only have a single inactive status code, no.
Now I'd like to bring up JX 674, which is the enacted version of SB 824. And go down to page 9. Okay, and there's a heading special identification card. Do you see that? The very top of this page.
Oh, yes, I do.
And these are the special DMV issued identification cards that may be used to vote under SB 824, correct?
I believe that's correct, yes.
Okay, and I'll represent to you that they are. If we go down to D2 at the bottom of this page, it says that notwithstanding subsection B of this section, for a person whose valid driver's license, permit, or endorsement is required to be seized or surrendered due to cancellation, disqualification, suspension, or revocation under applicable state law, the division shall issue a special identification card to that person without application, if eligible to receive a special identification card upon receipt by the division of the seized or surrendered document. The division shall issue and mail via first-class mail to that person's address on file a special identification card pursuant to this subsection at no charge. So this indicates that under SB 824, a person whose driver's license is surrendered or seized will automatically be sent a photo ID that can be used to vote so long as they're eligible for that ID, correct?
That is correct, and I believe I reference this in my main December report as well.
And that is a feature of SB 824 that was not present in HB 589, correct?
Objection,
As
Your
I sit
Honor.
here today,
Excuse me, Professor Quinn. Objection, Your Honor. I believe we're veering outside of the scope of both the rebuttal case and the rebuttal direct exam now. The comparisons back to HB 589.
The objection is sustained.
Let's go back to your affidavit now. I'd like to look at footnote 10, speaking about the 1,668 individuals with 2 or more non-active status codes. And you say that 43% of those were African American, correct?
733 of the 1,668 are African American. I believe that's 43%. Yes.
Okay, and so that's a disproportionate number of African Americans compared to the voter file, correct? It's about twice their prevalence there.
I don't recall the exact number. 43% is larger than the fraction of the percentage of African Americans in the voter file by my recollection.
Okay, now I'd like to go to JX5, which is your report in this case. And I'd like to go to paragraph 42 on page 12, where you're discussing the DMV IDs. Okay, and I'd like to look particularly at the sentence that starts, although expired IDs. Okay, and you say there, although expired IDs were removed from the database, driver's licenses that were listed in the North Carolina driver's license database as being canceled, suspended, or inactive were included and considered valid identification for the purposes of the matching process. Now, you don't disclose here that you excluded about 500,000 non-active licenses, nor that this resulted in 1,668 individuals being excluded from the matching analysis entirely, correct?
So as I testified yesterday, that deduping process has no impact on the matching analysis for those with active IDs, which is 99% of those with multiple forms or multiple status codes. I do note in this report that I include 1.5 million, or I misspoke. In my declaration of April 27th, I state that I did include 1.5 million approximately individuals who have these forms of non-active ID. And so I don't see anything that is inaccurate or misleading here. The deduping process had no appreciable impact on the results that I found in this main report of December.
Just so we're clear, though, regardless of whether the impact, you didn't anywhere in your initial report, in this case, disclose that you had conducted that deduping process, nor that this resulted in the exclusion of 1,668 individuals from your matching analysis, correct?
So there were a number of data cleaning steps that I did not explicitly go through. I believe this is about a 50-page report, maybe slightly longer. I didn't see the need to go through every particular data cleaning step that I engaged in. It would have been a 1,000-page report if I would have done that.
Okay, in this particular step that we've been discussing, you did not disclose in your report, correct?
That I deduped the status file. I did not state that explicitly, no.
And you never disclosed this information before producing your affidavit on April 27th, correct?
I would disagree with that. I produced all of the code files that were used in the data processing for the matching analysis. And in fact, that is how Dr. Thornton saw this. So I did disclose it through the code.
Okay, so you disclosed it through the code, but not in your report. And that's how Dr. Thornton was able to deduce that you had removed these status codes, correct?
I believe that to be the case. I obviously haven't spoken to Dr. Thornton about exactly what she did.
Okay. Now I'd like to look back up in this paragraph where it says because SB 824. And You say, because SB 824 requires acceptable forms of DMV-issued photo ID to be non-expired or expired for 1 year or less, except for voters who are 65 years of age or older at the time of voting, whose ID was non-expired at the time of their 65th birthday. I removed expired IDs from the DMV database that expired prior to September 20th, 2019, except for those individuals who are 65 years of age and older whose DMV issued ID was unexpired on the date of their 65th birthday. And just to make sure that I understand this correctly, I'd like to give a hypothetical. If there was a DMV record for an individual—
Objection, Your Honor. Apologize, Mr. Patterson, but this question of expiration dates also appears to be well outside the scope of Professor Quinn's rebuttal testimony. He testified to the claim that he removed individuals with canceled, suspended, inactive status codes, which is a discrete subject compared to expiration dates.
May I be heard, Your Honor?
Well, yes, and you can finish your question too. I didn't understand.
Okay,
exactly
I was in the middle of my question, actually.
You can finish your question for sure.
Yeah, okay. And on direct, Professor Quinn testified about having the status code database, and he also testified about his understanding of the driver history table and whether that led to, in his mind, the exclusion of, I believe he said he thinks he had all the information he needed in order to conduct his matches. And so that is where I am going with this line of questioning. Is directly responsive to what he said during his direct testimony.
Okay, go ahead and ask your question again.
Okay. So the question is, I'm just trying to understand what you wrote in this sentence. And I was going to give a hypothetical, and that would be of a DMV record for an individual who is under 65, and the expiration date is listed in the database as September 1st, 2019. And my understanding is that that individual would be excluded from your analysis, even if they had an active status code. Is that right?
And you object to that question, Mr. Williams?
I do, Your Honor, simply because the question of expiration dates and how they were applied in the analysis was discussed during plaintiff's case in chief, and I disagree that it was within the scope of Professor Quinn's rebuttal testimony, as he did not testify to the question of expired IDs.
The objection's overruled. You may answer the question.
So I'm sorry again, Mr. Patterson. Could you just the last part of the dates were that were in your hypothetical?
Yeah. So if a person was under 65 and their expiration date was September 1st, 2019, they would be excluded even with an active status code. Is that right?
Yes.
And you only had one expiration date for each individual in the DMV file. Is that right?
That's correct. Each driver's license number, customer ID was linked to a single expiration date.
And if an individual has multiple status codes, but you only have one expiration date, does that indicate that you potentially are missing some information on expiration dates for that individual?
What I can tell you is that the information that was produced to me by DMV states that their production was the current production as of, I believe, September 20th, 2020. And so my understanding is the expiration date I'm seeing is the most current expiration date. But to the
Okay.
extent that an individual may have more than one expiration date for different forms of ID, I only have one expiration date.
Okay, and now I'd like to bring up JX4, which is the Thornton rebuttal report. And I'd like to go to paragraph 50 and to a sentence that starts, however, as Brian Neesby. Okay, and she states there, however, as Brian Neesby described, the DMV maintains other data tables, including the driver history, DMV_driver_hist file, which consists of other driver's license issuances, even if unexpired, including DMV photo ID cards, data which were not produced. Now, is Dr. Thornton correct that the DMV_driver_hist file was not produced?
I didn't receive a file with that name. I think I testified to that yesterday.
Okay. So since you did not receive a file of that name, you did not use that file in your matching analysis, correct?
That is correct.
Okay. Now I'd like to go down. There's a footnote 35 that's called in that sentence there. And Dr. Thornton cites affidavit of Brian Neesby and Curry et al. Do you see that?
I do.
Okay. Now I'd like to bring up that affidavit, which is JX 794. And this is affidavit of Brian Neesby. And just real quickly on page 2, I'd like to go where he says scope of this study. And he says, I will analyze the methodology Dr. Stewart used in predicting how many registered voters in North Carolina allegedly do not possess a license with the North Carolina Department of Motor Vehicles. Now, in your 2015 matching analysis in Curry, used the same methodology as Dr. Stewart, right?
I believe, as I previously testified, it was not exactly the same. The match strings were the same, in part because there was only one way to access the federal forms of ID in that case, and it wasn't possible to change any of that. There were some differences in the matching analysis, though.
And what were those differences?
As I recall, the major difference, I think that produced some differences between Dr. Stewart's results and my results, was that in situations where, say there were 2 records in the voter file that had the same value of a composite match field, and there was only one DMV record that matched to those individuals, I recorded that as a match for both individuals in the voter file. So again, a conservative decision. Whereas I don't recall exactly what Dr. Stewart did. I think he may have picked one of those individuals out of the voter file rather than match to both of them.
Okay, but in terms of data you had from the DMV, your methodology was the same. Is that correct? The information
I guess I would
from the DMV.
separate the methodology from the data. As I stated, the methodology was not exactly the same. It was certainly very similar. I wouldn't disagree with that. In terms of the data production from DMV, I honestly don't recall whether the exact files were used or not. I believe they were very similar, if not exactly the same.
Okay, now I'd like to go down to page 5. And this is the discussion that Dr. Thornton cited in her report. I want to look specifically under the heading, the MVD_driver_ID table is not the only source of information regarding DMV photo identification cards. And Mr. Neesby says the first major problem is that only records from the MVD_driver_ID are included in the resulting query. However, another table in SADLS contains records of North Carolina DMV photo identification cards, the MVD_driver_hist table. Despite the hist suffix, this table contains both expired and unexpired licenses. The MVD_driver_ID table contains only one issuance or application. All other issuances are moved to the MVD_driver_hist table, even if they are unexpired. So the SADLS, is that the information that the DMV has from which the information that was produced in 2015 and in this case comes?
I believe so, yes.
Okay. And in this case, in 2020, your analysis, you used the MVD underscore driver underscore ID table, correct?
That was the name of the table that was produced in 2020. Just a point of clarification, there's a 6-year gap between those two, and I don't know that DMV is consistent in how they're naming things or using their table layout across that time period.
Okay, and in your 2020 analysis, you did not have, as I think you confirmed, this MVD underscore driver underscore HIS table, correct?
That table was not produced to me.
Okay, and so now I'd like to bring
I'm
up.
sorry, Mr. Patterson,
Yes.
just to be totally clear about it, and related to my last answer, a table with that name was not produced to me.
Okay, and there was no table produced to you that had expiration dates beyond those in the MVD underscore driver underscore ID table. Is that correct?
I believe that was the only source of DMV expiration dates that I received.
Okay. And now I'd like to bring up LX 271, which is Mr. Neesby's testimony in this case. I'd like to go to page 63, line 4. Okay. I think we're still getting the correct transcript up. This should be LX 271, I believe, the April 27th transcript. Okay, and we'd like to go to page 63 and line 4. Okay, and Mr. Neesby is asked, are you familiar with a field in the DMV database known as the MVD driver history table? I am. And what is that driver history table, if you could explain that to us? That contains driver ID issuances, and it contains those that aren't the most current issuance. And I differentiate that just because it's not the most current doesn't mean it's expired or inactive in any way. Now, this testimony from this Mr. Neesby is consistent with what he said in his 2015 affidavit, correct? I
believe it is, yes.
And you don't have any reason to question Mr. Neesby's testimony on this issue, correct?
I have no reason to either believe or disbelieve Mr. Neesby's testimony. I don't have access to this table, so I can't speak to what it contains.
Right, but Mr. Neesby would be better situated to speak to the data possessed by the North Carolina DMV than you, correct?
To the extent that he has access to data that I have not been given access to, he would be able to say things about the data that he has seen that I have not seen. But again, my understanding is that the request for production in this case was very broad. And what I can say is that I didn't receive this file. And if it was relevant for the request, I would have no reason to think the DMV would not understand what's responsive to the request and what's not responsive to the request.
I'd like to go back to Neesby's affidavit and go to paragraph 14. Okay, and he says the impact of such a mistake is enumerated below, and this is the mistake of excluding the DMV underscore driver underscore HIS table. And the first bullet says there are 2,936,150 customers with unexpired licenses in the DMV underscore driver underscore HIS table. And then if we go down to the last bullet, he talks about, in the intervening bullets, looking at that data, he says at least 38,801 of these 97,563 customers are on Dr. Stewart's no match list, even though they had an unexpired license. Now, voters in a similar profile in your matching analysis that have an unexpired license in the DMV_driver_HIST table, if there were such voters, but that had have an expired license in the data you used that you excluded due to the expiration parameters in your analysis, they potentially could not match despite having a valid non-expired DMV ID. Is that correct?
Objection, Your Honor. May I be heard? We object on a number of grounds to this question. This affidavit is from 2015. It is not critiquing the expert work of Professor Quinn in this case, or even in the 2015 case. Further, Mr. Neesby did not testify to this information at trial, as this affidavit was excluded for that purpose. So on these grounds, we believe that it is inappropriate to ask Professor Quinn this question.
If I could be heard, Your Honor.
Yes, sir.
There are multiple reasons why this is appropriate. First, he said he thought he had all the information he needed to do his matching. Second, as the testimony I just showed, Mr. Neesby indicated that there is still this table during his testimony with unexpired license information, as there was in 2015. Third, Professor Quinn acknowledged that he believes the data from the DMV that he and Dr. Stewart had were the same back in 2015. And fourth and finally, this is the very passage of this affidavit that Dr. Thornton relied upon in her rebuttal of Professor Quinn's analysis. So this has already been used in response to Professor Quinn's testimony, and I'm just asking him a question about that.
Give me just 1 second, if you will. The objection is sustained. I will allow you to ask the witness the question and get your answer as a proffer.
Okay, could the court reporter read that question back? I don't know if I can reconstruct it.
I certainly don't remember it.
Ms. Fawcett, are you able to do that?
Yeah, it takes me a minute to get my unmute. So yeah, give me a minute. It's a long one, okay? So question, I'd like to go back to Neesby's affidavit and go to paragraph 14, okay? And he says the impact of such a mistake is enumerated below, and this is the mistake of excluding the DMV_driver_HIST table. And the first bullet says there are 2,936,150 customers with unexpired licenses in the MVD_driver_HIST table. And we go to the last bullet, the intervening bullets, he says at least 38,801 of these 97,563 customers are on Dr. Stewart's no match list, even though they had an unexpired license. Now, voters in a similar profile in your matching analysis that have an unexpired license, and that in the DMV underscore driver underscore his table, if there were such voters but have an expired license in the data you use that you excluded due to the expiration parameters in your analysis, they potentially would not match despite having a valid non-expired DMV ID. Is that correct?
So, so let me try to put some context on this. So the first thing to note here, to the extent we're looking at any of the numbers that are on the screen that reference Dr. Stewart's no matching list, as I stated earlier, one of the big differences between my 2015 analysis and Dr. Stewart's 2015 analysis is that I had a more permissive match criterion. I generated more matches than Stewart did. And so I want to be really clear that this 38,801 and 97,563, I'm nearly certain that those aren't the right numbers for my report. So the other thing I would note is that in my rebuttal report to Dr. Callanan, I did do an exercise of what happens if we include IDs that are expired in the files that I had access to in this litigation. And what I found is that even when you allow expired licenses that were expired, I believe up to 10 years ago, the racial disparity remains and in fact increases as we include expired licenses in the data that I had access to. So having said that, as I understand the counterfactual or the hypothetical that Mr. Patterson has given me here, is that if there is a person in the driver ID table whose current license shows an expiration date sufficiently early in time that it would not qualify under the rules that I use to exclude expired licenses. But that individual did have an unexpired license in this other table, which Dr. Neesby says exists, but I, again, have no information on whether it in fact does exist or not. If there is such a person who would have an unexpired license in that other history table, then yes, that person should be a match. But I think there are a lot, right, as with any hypothetical, there are a bunch of things that are not known, which is what makes it hypothetical.
Okay. Now I'd like to go back to LX 271 and the same Neesby testimony we were just looking at.
Before you do,
yes.
let me just say one thing. Our court reporter's ability to read your previous question back and the accuracy with which she did so is fascinating to me, and I can't let that moment go by without giving her a shout out and saying we have one awesome real-time court reporter. So sorry to interject there, but I just had to do it, and you may ask your next question.
No, I disagree 100%, and it also made me think you need a more skillful questioner. Now, out of proffer mode, and back at this testimony from Mr. Neesby, and again, his answer, the question was, are you familiar with the field in the DMV database known as the MVD driver history table? I am. And what is that driver history table, if you could explain that to us? That contains driver ID issuances, and it contains those that aren't the most current issuance. And I differentiate that just because it's not the most current doesn't mean it's expired or inactive in any way. Now, I just want to make sure I understand and that it's on the record that to the extent Mr. Neesby is correct that there is a data table that has unexpired licenses, that you did not receive, and that the information that you received for those individuals showed an expired license. It's possible those individuals could be false negatives in your matching analysis, correct?
It's certainly possible. But again, as I noted earlier, the analysis I did in my rebuttal report to Professor Callanan does look at what happens when we include expired licenses and allow those to be counted as matches. And it doesn't affect the results that I reached in my main report. If anything, the racial disparity gets larger.
Right, but that analysis was not limited to individuals who have unexpired licenses in a data field that you do not possess, correct?
That analysis assumed that everyone who in the files that I did possess who had an expired license could use that expired license to vote.
So it was not limited to individuals who have an unexpired license in data that you did not possess, correct?
I'm sorry, Mr. Patterson. I don't mean to be difficult, but there was a double negative there, and I'm having a hard time
Okay.
making sure I understood which part is being negated.
Okay, so let me try to rephrase it. So your analysis and rebuttal to Professor Callanan looked at all expired licenses and not a subset of expired licenses that are correlated with an unexpired license in data that was not produced to you in this litigation. Is that right?
That is correct. The fact that I didn't have the data that was not produced to me means that I couldn't subset things down based on values in that hypothetical other table.
Now, you recall that you may have looked at the 2015 Neesby affidavit at some point after it was submitted in the Curry litigation. Is that correct?
I believe that was my testimony. Yeah, I've certainly looked at it in the last few days. That's right.
Okay, and you also, though, you looked at it back when it was initially produced. Is that correct?
I don't recall if I looked at it when it was. I mean, if we're talking about like during the Curry litigation, I'm not certain about that. It's plausible to assume I would have been shown that, but I don't know for certain with certainty that I did see it at that point.
Okay, but you believe you looked at it at some point before you prepared your expert report in this case. Is that right?
I think that's correct, yes.
Okay, you did not specifically request that you be provided the MVD_driver_hist table in this litigation, correct?
No, I didn't make specific requests for any specific tables. The reason being is that I'm not a data steward for DMV, so I don't know what all their internal tables are called, and if their naming has changed over time. So I made a broad request to council that I would like all relevant DMV information related to IDs. Council crafted a request for production. My understanding is that request was broadly worded. And as I stated, I have no reason to think that DMV wouldn't understand what would be responsive and what wasn't responsive.
And when you received the data and saw that there was only one expiration date associated with each driver's DMV customer file, you did not follow up to ask whether there was other data that the DMV had with additional expiration dates, correct?
I did not.
I have no more questions at this time.
All right. Mr. Steve, do you have questions on behalf of the state defendants?
I do not, Your Honor. Thank you.
Very well. Mr. Williams, do you have further direct examination or redirect examinations?
I do, Your Honor. Thank you. Good morning, Professor Quinn.
Good morning.
Yesterday, Counsel for Legislative Defendants asked you a number of questions regarding your understanding of Dr. Thornton's claim that she offered on the stand. Do you remember some of those questions?
I do.
Before I start, just for clarity of record, in the context of this discussion, do you understand the term non-active status code and non-active license to mean the same thing?
Yes, I would say so.
Okay, I believe there was some contention over whether Dr. Thornton's opinion was that you dropped around 500,000 people from your matching analysis or around 500,000 status codes. Is that accurate? My description of the questions?
I think that's what the dispute boils down to, yes.
Okay, I would just like to simplify this as much as possible. Could you please explain for the court what the difference between these two claims would be? So first, with respect to your matching analysis, what would it mean if you dropped around 500,000 people corresponding to 500,000 unique driver's license numbers?
If I dropped 500,000 people, individuals, driver's license numbers from the DMV files, it would be impossible to for any of those DMV records to provide matches to the voter file. So that could be a serious, have a serious effect on my matching analysis. On the other hand, the status codes are for people who have multiple licenses. Dropping the inactive status code for an individual who has multiple status codes doesn't affect the matching analysis at all if they have an active license. All of those individuals still show up in the DMV files that I used for the matching analysis, and they can provide potential matches to the voter file. I mean, one way to think about it, that I don't know if this is helpful for people or not, but people can vote in North Carolina. Driver's licenses can't vote in North Carolina. I didn't drop people who had active licenses from the DMV file. I dropped status codes that corresponded to particular types of licenses, but kept the active status code for those who had an active status code as well.
Do you recall being asked some questions about the trial transcript?
Yes.
Okay, I'd like to publish for the court Plaintiff's Exhibit 137, which is the draft trial transcript, in this case for April 26. And if we can direct your attention to page 152, lines 17 through 23, I'll just represent to you this was the final exchange on this topic during trial on Monday, April 26. Please read this exchange where Ms. Riggs asked a question to Dr. Thornton on cross-examination.
So Ms. Riggs' question is, okay, let me just wrap this up. If it turns out that Dr. Quinn retained in his analysis the most recent active record for such an individual, then you would be wrong that such an individual is dropped from the analysis, correct? And Dr. Thornton's answer is, well, he may state that I'm incorrect, but there's only one record, only one issuance in the data provided.
Okay, and Professor Quinn, do you recall listening to this exchange live?
Oh, I'm sorry, Mr. Williams, the audio cut out for a second.
Oh, can you hear me now?
Yes.
My apologies. Do you recall listening to this audio live while Dr. Thornton was on the stand?
Yes.
Okay, and what was your understanding of Dr. Thornton's critique after hearing this?
Well, so all of this is tied to Dr. Thornton's report, and where this sort of issue of the canceled, suspended, inactive licenses shows up is a place where I forget the exact subheading for that section, but it's something about my matching analysis and the fact that my matching analysis has a large number of false negatives, as I recall. And so what I took this to mean is that her claim is that I was dropping people and that this was affecting my matching analysis.
Okay, thank you. I'd like to move to the transcript for the next day, which is PX 138, the draft trial transcript, in this case for April 27th. And I'll direct your attention to page 37, lines 6 through 23, and I'll just represent for the record that this is the final exchange on this topic during Dr. Thornton's testimony and trial. Please read the exchange where Judge Ofalu asked Dr. Thornton a number of questions, and you can just read this yourself. And once you finish, I'll ask you what your understanding is.
So again, I mean, it's a little difficult to parse exactly what this means, but I take this to mean that Dr. Thornton's claim is that I'm doing something to exclude individuals from the DMV file that's having an appreciable effect on my matching analysis. And it would seem to mean that I'm excluding 500,000 records from the DMV file that could be potential matches.
Okay, and Professor Quinn, is this consistent with the opinion in your declaration?
Well, so it's my view of what Dr. Thornton's view is consistent with what I said in the declaration. My view of whether this is correct or not is not Dr. Thornton's view of whether this is correct or not.
Okay, and briefly, can you explain why it is not correct?
Well, as I stated, to the extent that Dr. Thornton is claiming that I'm removing driver's license numbers, which would be individuals, from the DMV file prior to doing my matching, and that this is having an appreciable effect on my results, it's just not the case that I removed 500,000 individuals or 490,000 individuals or 482,000 individuals who have canceled, suspended licenses from my analysis prior to from the DMV file prior to doing the matching. That's just simply not correct.
Thank you, Professor Quinn. I have no further questions.
Mr. Patterson, do you have questions?
I just have one question. Professor Quinn, can you point to any statement from Dr. Thornton where she expressly says you removed about 500,000 individuals who had canceled, suspended, or inactive licenses?
As I sit here today, I can't point to any particular text where she uses the word individuals. I do believe in her rebuttal report, in that section I was referencing where she discusses the canceled, suspended, inactive IDs, I believe she uses the term those. And in the context of that paragraph where she seems to be talking about my matching analysis and my ability to match voter file records to DMV file records, while it doesn't say individuals, to the extent that those is referring to records that would matter for the matching, that I interpret that to be most plausibly a claim about either driver's license numbers or individuals in the in the DMV file.
So the answer is no, you cannot point to any statement from Dr. Thornton where she expressly says you removed about 500,000 individuals who had canceled, suspended, or inactive licenses, correct?
As I sit here today, I can't point to a particular point in her rebuttal or her trial transcript where she states explicitly that what you just stated.
Okay, I have no further questions.
All right. Mr. Steed, do you have any questions?
No questions, Your Honor. Thank you.
Mr. Williams, do you have any further questions?
No further questions, Your Honor. Thank you.
All right. Mr. Quinn, Dr. Quinn, thank you very much for your testimony. You're now free to leave the courtroom.
Thank you, Your Honor. Have a good day.
Thank you. You as well. All right. Ms. Riggs, who will be the next witness in the plaintiff's case in rebuttal?
Thank you, Your Honor. Plaintiffs will call former Senator Floyd McKissick.
And Your Honor, for the legislative defendants, Ms. Moss will handle this witness.
And for the state defendants, Terrence Steed will be handling this witness.
And Ms. Riggs, will you be handling the witness on behalf of the plaintiff?
I will, Your Honor.
Okay. Okay, can we let Mr. McKissick into the courtroom? I think him there. Mr. McKissick, can you hear me?
Yes, I can.
Okay, great. Are you ready to give your testimony in this case?
Yes, I am.
All right, would you please raise your right hand?
Do you solemnly affirm that your testimony to the court be the truth, the whole truth, and nothing but the truth, and this is your solemn affirmation?
I do.
Thank you. You can lower your hand.
All right, Ms. Riggs, you may proceed.
Thank you, Your Honor. Senator McKissick, can you please state your full name for the court?
Floyd Bixler McKissick, Jr.
What is your current occupation?
I've been an attorney for approximately 38 years here in the state of North Carolina. However, I'm currently serving on the North Carolina Utilities Commission as a member.
Have you ever served in the North Carolina General Assembly?
Yes, I served the North Carolina Senate between 2007 and January of 2020.
Senator McKissick, when you were in the Senate, did you serve in any leadership roles within the Senate?
I served as senior deputy Democratic leader for approximately a decade or so. I also chaired the legislative Black Caucus for 2 years.
By testifying today, Senator McKissick, are you waiving your legislative privilege for any matters beyond those relating to Senate Bill 824?
No, I am not.
Are you waiving the legislative privilege of any of your former colleagues in the North Carolina Senate?
No, I am not.
Are you familiar with Senate Bill 824?
Yes, I am.
Did you vote for Senate Bill 824?
No, I did not.
Senator, do you know former Senator Joel Ford?
Yes, I do.
How do you know him?
Well, he served as one of my colleagues in the state Senate for a number of years. I can't recall the exact year he joined the Senate, but I'm thinking it was around perhaps 2012 or so. And at one point for about 2 years, we were seatmates in the Senate chamber.
How would you characterize your relationship with former Senator Ford?
We were cordial and polite to each other, but we did not have a strong bond and a strong friendship in a way that I did with some other colleagues in the Senate.
Was former Senator Ford a sponsor of Senate Bill 824?
Yes, he was.
Senator McKissick, are you familiar with former Senator Joel Ford's affidavit in this case?
Yes, I am.
Are you aware that Mr. Ford stated in his affidavit and testimony that the Democratic caucus strategically decided to limit debate on Senate Bill 824 for litigation purposes?
Yes, I'm aware that he made that statement.
Is that true?
It is not true. That is not all what occurred. In fact, Senator Ford was not even participating in Democratic caucus meetings at that point in time. He had estranged himself from the Democratic caucus in an earlier point in time and for a protracted period of time. So he would have not been attending our meetings nor been privy to the thought, discussion, and information that would have been shared by Senate Democratic members.
And just to establish, how do you know that Senator Ford stopped caucusing with the Democrats?
Because I was a consistent attendee at our meetings as the members of the Senate Democratic Caucus convened. I always attended our meetings. There may have been a few meetings where I got there a few moments late or had to leave a few minutes early, but I was there virtually 100% of the time.
Without seeking to disclose anything that might be privileged information, as a member of the Senate Democratic Caucus, did you seek to truncate debate on Senate Bill 824 for strategic purposes?
Absolutely not. I did not. No.
Senator McKissick, based on your long experience serving in the North Carolina Senate, would you consider the process, excuse me, would you consider the process by which Senate Bill 824 was enacted to be bipartisan?
Objection, Your
Absolutely
Honor.
not.
Just 1 second.
Can I
The
Can I hear what the basis of the objection is and respond?
Yes, the objection, Your Honor, is this goes beyond what I believe the court's instruction was, which was true rebuttal. Whether and how the bill was enacted and whether it was enacted pursuant to normal legislative process was covered by plaintiff's other witnesses, and this would be cumulative evidence that if they wanted to put in from Senator McKissick, they could have done so in their case in chief.
Your Honor, may I be heard?
The objection's overruled. You may answer the question.
No, it was not a bipartisan bill in any respect. I've worked on bipartisan bills where I worked with members of the Republican Party that were members of the Senate, and we worked collaboratively. We drafted different sections of the bill. We discussed different sections of the bill. We came up with what we thought was a consensus piece of legislation where there was a lot of give and take and sharing of information. And that collaborative process took place before the bill was ever filed. This was not a bill where that type of exchange of information, exchange of thoughts and opinion took place. In fact, it was pretty rushed. I mean, right after the constitutional amendment was passed, we were called back into session shortly after Thanksgiving, and the bill kind of was heard and went through the process in about a day and a half. So, you know, it was filed immediately. There was not this collaborative, deliberative process where you worked on things in that way. And I can think of a number of bills which I was a part of where that collaborative model and bipartisanship existed.
So, Senator McKissick, I understood your testimony that bipartisan bills involve discussion before the filing of the bill. Is there anything about the amendments process that is an indicator to you based on your experience of whether a bill is bipartisan or not?
In the amendment process, you may tweak or change a provision of a bill, but the bill as base legislation that's being debated and discussed in committee is already set in stone. So, I mean, you may be able to mitigate adversities of a bill or to make it less harmful in some respect that you might consider to be harmful by submitting an amendment and discussing an amendment and getting an amendment passed. But it doesn't change the basic legislation that's been introduced. You may be modifying some provision or clarifying some technicality, and that's really the only thing amendments typically do.
Senator McKissick, are you aware in this case that legislative defendants have argued that your comments on the floor during third reading of Senate Bill 824 indicate that the process was bipartisan?
I became aware that they made that representation. I think that's an inaccurate characterization of my comments.
Okay,
what
Senator
I tried-
McKissick. Sorry.
What I try to do as a legislator when I was in the legislature was to be courteous to my colleagues. I always found it being courteous to people and extending common courtesies was a an attribute that I found was helpful when I wanted to run other amendments in the future, but particularly if there had been an amendment that I had run that had been accepted, because so often when amendments are run, if you're in a minority party member, they just table them. They don't even consider them. They don't even ever come up for a vote. So expressions that I made was being courteous of the fact that amendment that I filed was in fact, adopted. So, I mean, that's really the only thing that represented, and those are typical of remarks I might have made on many other occasions during my years in the Senate. But it did not reflect the fact that what we had in this case was a bad bill that I did not support. I did not vote on it. And I couldn't have. I mean, I wish it had been a better bill.
Senator McKissick, I want to show you what's been marked as Joint Exhibit 773, which were your comments during the third reading of Senate Bill 824 in the North Carolina Senate. And I think, I'm sorry, Ashley, do you have the page number? Right, yeah, starting at line 3.
Starting at line 3.
I think that's right.
Oh, yeah, I see
Yeah.
that, yes.
Yeah, Ashley, can you highlight 3 through 8? Can you explain to the court why you said what you said there?
Let me take a moment to read it.
Yes, please.
Ms. Riggs, can I indulge you for a moment? When there's a longer answer, do you mind muting your microphone? Because it is hissing over his, and his is a lot lighter of us. You come out loud and clear, and his is a much softer voice.
I'm happy to do that, Ms. Fawcett. Thank you for asking.
Thanks.
Okay, yes, I've read it. What was the question?
Can you explain to the court why you said what you said here?
I was expressing appreciation simply for the fact that the amendment that I had drafted that did change some provisions of the bill was essentially adopted. It was more about being polite and courteous, and that was the extent to which I intended to express any thoughts or opinion relating to the process. I certainly was not suggesting or implying that this had been a bipartisan bill with strong bipartisan participation and effort in the drafting of the bill prior to its introduction. So that was the purpose and expression of what I stated at that time.
Thank you. You can put that down, Ashley. And at the end, Senator McKissick, did your comments affect your vote on the bill?
No, not at all. I mean, I did not vote for the bill because I thought that it was having a substantially adverse impact upon people who did not have IDs in hand today. And the data that I had seen suggested there were probably upwards to about 300,000 people that could lawfully vote at that time that would have potentially been disenfranchised because they did not have IDs that they could present or that would be qualified at that point in time. So, I mean, it disproportionately impacted low wealth individuals as well as African Americans. And, when you're talking about 300,000 people, that's a lot of people. I mean, we've had a lot of elections decided by merely my gosh, a handful of votes. I mean, when Governor Cooper won, it was only a 10,000 vote margin. This past year, Sherry Beasley lost by 400 votes. When I think back when Obama won back in 2008, it was 13,000 votes. When I think back to when he lost in, I guess, 2012, it was 100,000 votes. So this idea of 300,000 votes was profound and significant. And if we were going to have legislation, we needed to enable as many people as possible that did not have IDs to obtain them and to make them accessible so they could continue to exercise that constitutional right that they have. So I didn't vote for it because it did not meet what I thought were standards that were necessary to certainly win my approval. And I think we could have gotten there if we had come back in a long session and worked on it. And I think that could have helped a lot. I think the fear of the Republican majority was that when we reconvened in January for the long session year, they would no longer have a veto-proof majority because their veto-proof majority would have been replaced by an additional number of Democrats. But at that point, we could have worked really strong, really hard, really collaboratively to come up with a good bill that would have been, mitigated the potential impacts that a voter ID bill would have. That's the way I would characterize it.
Hey, stop right there if I can. We're going to go ahead and take a morning recess for about 15 minutes. We'll come back at 10:30. Okay, so recess for